Known for its breathtaking mountain views, fantastic wildlife, and deep powder that allows for some of the best backcountry skiing and snowmobiling in the state, Cook City is a tiny mountain town nestled in the middle of nowhere. However, its history of mining reveals itself in the mountains pocked by past mining attempts to strike it rich, and abandoned mining equipment that remains strewn across the surrounding drainages. Historically, Cook City was not known for its environmental conservation, yet one of the best-known land use battles of the 1990s rose from the fierce voices of this small mountain town. At the doorstep to Yellowstone National Park, Cook City locals battled an international giant to secure their rights as citizens to environmental protections that were threatened by an antiquated mining law. A conflict in the making was fueled by President Ulysses S. Grant as he signed two opposing laws into action, only 2 months apart. On March 1, 1872, the Yellowstone National Park Protection Act created the world's first national park, designed for the benefit and enjoyment of the people. 2 months later, President Grant signed the 1872 General Mining Law, designed to promote westward expansion. Fast forward 120 years to the highest and most remote town in Montana, Cook City, nestled between 3 designated wilderness areas and located less than 4 miles from the northeast entrance to Yellowstone National Park. And the stage for our conflict begins. Those who love Yellowstone were shocked by the potential for a large international gold mine to extract the very values at the heart of the park's mission statement, due to what many referred to as a law without a brain. Mike Finley, who was the director of the Greater Yellowstone Coalition, a Montana-based environmental organization, stated, "I'm stunned this could be taking place with such potentially devastating impacts. How can the logical mind approve of this?" Stuart Coleman, the natural resource director of Yellowstone National Park, agreed. "If you were going to throw a dart at the map of the United States and place a gold mine there, those mountains would probably be the worst place a dart could land." The problem lay at the core of the 1872 General Mining Law, which states, "All valuable mineral deposits in the lands belonging to the United States are hereby declared to be free and open to exploration and purchase, and the lands in which they are found to occupation and purchase." You heard that right. Based on the 1872 General Mining Law, public land can be purchased for no more than $5 an acre to become private land, which allows a mining company, even a large foreign one such as the Crown Butte Mining, to extract $800 million worth of gold from a mountain, yet pay 0 royalties to the U.S. government. Nor will the mining company be held responsible for any cleanup if the land and water is polluted, which is exactly what occurred at the Summitville mine high in the San Juan Mountains of the Colorado. In 1992, after extracting nearly 9 tons of gold, Galactic Resources of British Columbia, Canada, declared bankruptcy and left a $100 million cleanup cost for the U.S. citizens to pay. The Crown Butte Noranda mining officials swore the design of the New World mine was foolproof. "This mine's going to be a showcase. It'll be real state-of-the-art, a really classy operation," stated Alan Kirk, lead geologist for Noranda. "I don't think there will be a more modern or more sophisticated mining plan in the U.S., and that's just it. The General Mining Law was never written for the size of projects such as the New World Mine that would include a 77-acre plastic-lined lake filled 10 stories deep with toxic mine tailings until the end of time. This law was written for fellows with a pick and a shovel and a case of dynamite, and a mule or two, not for the size of companies such as Noranda, which will need to mine 4 tons of rock to extract 1 ounce of gold." Terry Martin, the Rocky Mountain Regional Director for National Parks and Conservation Association, stated, "From any perspective except those who stand to make private profit at the public expense, it makes no sense to mine there." Even independent geologists spoke out against safely containing the toxic slur in an avalanche-prone and earthquake-prone location for eternity. In March 1994, the publishers of Engineering News Record warned, "Don't experiment in a place where the price of failure is ruining a wild and scenic river or the oldest national park in the U.S." In a call for citizen action, Peter Angst of the Greater Yellowstone Coalition warned, "Unfortunately, this mine could be permitted if for no other reason than citizen apathy." Fortunately, those who loved these mountains the most were as fiercely protective as a mother grizzly and fought for their rights to clean water. From day one, the residents of Cook City said there would be no negotiating, no mine, period. In 1989, they formed the Beartooth Alliance, a grassroots, citizen-led environmental organization. that built the community support, wrote opposition letters, and increased awareness of the threat of the gold mine next to Yellowstone National Park.
The 1872 mining law is a classic example of taking a public asset, turning it into a private asset, and exporting the costs of doing that to other people. And so that's part of my job, and I'd argue anybody's job as a citizen, to make sure that people are making those calculations. And ultimately, that's what the Clean and Healthful Environment Clause in the state constitution is about. Look about things and think it out through before you start ripping things up and are having to deal with the consequences that nobody paid for. And the consequences land totally on the public one way or another.
With strong support from both national and international organizations, as well as support from outspoken individuals in the highest government positions, including President Bill Clinton, who during the New World fight coined the slogan, "Yellowstone is more precious than gold," the locals of Cook City and the growing Yellowstone Nation were on their way to a success story. In August of 1995, at the Buffalo Ranch in the Lamar Valley, the Serengeti of Yellowstone, President Clinton declared he was using all the power he had at the time to withdraw the New World District from future mining claims to protect the watersheds within the drainages of the Clark's Fork of the Yellowstone, Soda Butte Creek, and the Stillwater River, and the water quality and the freshwater fishery resources within Yellowstone National Park. Citizens' rights to clean water had prevailed, and 1 year later, on August 12, 1996, at the northeast corner of Yellowstone National Park, President Clinton confirmed.
As has been said before, this is a victory for everyone involved. The American people and our future win because Yellowstone will be protected from the environmental hazards of mining. Crown Butte's shareholders win because their property rights will be protected. We are all protected from years and years of expensive and bitter litigation. And while there is still work to do, and work in which the members of the general public must and will be involved, we are going to move forward. And this signing today means that it will come out the way so many of you have worked for so many years.
Fortunately, this particular fight ended with a historic win-win agreement, which preserved both citizen rights and private rights. However, how can two opposing laws, one for the preservation and protection of land, and the other for exploration and exploitation of land, exist without continued fights such as the New World Mine? At the celebratory gathering, Mike Clark of the Greater Yellowstone Coalition called for the reform of the general mining law.
In this agreement, the conservation community work to ensure that mining in the New World Mining District will never again threaten Yellowstone. It's in the agreement. We work to ensure these minerals and lands would be returned to the American people. It's in the agreement. We needed provisions to clean up the mess left over from 100 years of prior mining. It's in the agreement. And we insisted the public have an ability to comment and to examine every aspect of this deal. It's in the agreement. It's a good agreement. It's a fair agreement. But we should not forget that at the same year that Yellowstone was created, the 1872 mining law was passed. It's this bad law, badly outdated, that now needs to be changed. Mr. President and members of Congress, it's time to reform the mining law so the public has the same rights as mining companies on our public lands.
Thanks to the strong and resilient residents of Cook City who stood up for their rights as citizens to prevent the New World Mine, and to the voices of many others from around the world, today Cook City is known for its scenic mountain views and clear running mountain streams. However, Cook City was not always known as a quaint gateway town to Yellowstone National Park, because Cook City had been firmly established by the 1872 General Mining Law, which allowed westward-bound settlers to stake mining claims, turning public land into private ownership with the potential to strike it rich. In the 150 years since the signing of the General Mining Law, perspectives have changed, and Cook City's economy has shifted too, which is now firmly based on the 1872 Yellowstone National Park Protection Act.